So welcome everybody. Today we're running another of our regular data protection webinars or data protection law webinars. There are three of us talking today. I'm Tom Phipps. I'm a consultant lawyer with the firm. We also have Emma Harris and Hannah Pettit, and all three of us are members of Ashford's data protection team. A few housekeeping points before I start. Could you please all make sure that you've switched your mics off, just so we can minimise the risk of feedback. Secondly, just to make sure you all know that the webinar is being recorded. It will be available on our website for any of you to watch again, should you want to do so. But also, you might not want to put your camera on for that reason. And third, by all means, ask any questions of us in the group chat or by email afterwards. Because it's a webinar, it's difficult to take questions while we're talking, but we will answer any questions that anybody might want to raise if you email or put it in the chat. So what are we talking about today? Well, we're talking about international data transfers. I'm going to do an introduction to them, or introduction to the issues. Then Emma will talk about scrutiny and appropriate safeguards in more detail. And Hannah will take us through the UK International Data Transfer Agreement in some more detail. So, what is an international data transfer? Well, put simply, it's any transfer of personal data from the UK to another legal jurisdiction. And just as a reminder, personal data is any information relating to an identified or identifiable natural person. So anything that might identify them, whether it's self or in combination with other data. So it's information relating to employees, customers, contacts, just about anybody really, that might be transferred from the UK to another country. So why is it an issue from a legal point of view? Well, the problem is that individuals risk losing the protection of UK data protection laws if their personal data is transferred outside the UK and beyond the reach of UK law. So UK GDPR restricts transfers of personal data outside the UK unless the rights of the individuals in respect of that data is protected in some other way. So you can't make the transfer unless you can come up with another way of protecting the data. So how can you do that? Well, the first route is by way of an adequacy decision, and that's a decision of either the European Union or the UK ICO that the law of the jurisdiction to which the data is to be transferred is adequate, or in other words, it offers broadly equivalent protection to the UK. Countries which have the benefit of an adequacy decision include any member states of the European Union, and I've listed a few others there: Israel, Argentina, Uruguay and New Zealand. Very significantly, jurisdictions that don't have an adequacy decision include the USA, Australia and India. Now those are all very important countries from a data transfer point of view, particularly in the case of the USA and India. It's very common for UK personal data to be transferred to the USA or India. So the next question is, what do you do then if they don't have an adequacy decision? Well, you have to put in place a contract which contains standard contractual clauses, or SCCs for short. In essence, that's a contract that puts obligations on the data exporter and importer regarding rights for the individuals whose personal data is transferred. And those individuals can enforce those rights directly against the importer and exporter. The European Commission issued new SCCs on the 4th of June last year, but those aren't valid for transfers under UK GDPR. The ICO has now issued new data protection clauses which replace those old EU ones, and they'll be in force in 5 days' time, in fact, on the 21st of March. Very important when using standard contractual clauses to analyse what the parties' roles are, whether the transfer is from a data controller to a processor, or whether it's a controller to a controller, or a processor to processor, because there are different required clauses for each scenario. Are there any exceptions? Well, there are exceptions. Most of them are pretty esoteric. One just to mention, because it's superficially attractive, is explicit consent. It is, in theory, possible to transfer data outside the UK without an adequacy decision or without SCCs if the individual explicitly consents. Now, that's all very well, but in order to get that consent, you have to go through those steps which I've identified on the slide. And in particular, I want to mention the individual's right to withdraw consent at any time. You have to tell the individual about that, and the individual can do that at any time. And this makes the explicit consent exception a bit of a problem, because if you've outsourced all your employee payroll information to India, for example, but one member of your team decides they're going to withdraw consent, that means that individual's payroll has to be dealt with on an individual basis and not as part of your service provider. So it's not really something that is a lot of practical use, apart from for one-off occasional transfers. Finally, I just want to say something about whether SCCs are enough. Is it okay as long as you put SCCs in place? Well, what the law actually requires the parties to do is to put in place appropriate safeguards. Now, SCCs are part of the appropriate safeguards a set of requirements, but they're not the whole thing. You also need to do a transfer impact assessment, which will assess whether data subjects will continue to have equivalent protection, including obviously having those SCCs in place. For example, there may be local law issues which would trump any contract you put in place, and that's something that needs to be considered. Also, it's important to do some due diligence on the importer, such as in relation to what cybersecurity the importer has in place, what its reputation is. Is it a specialist, well-reputed service provider with a good track record? That type of thing is key. You need to satisfy yourself about that. And also, the jurisdiction to which the data is being transferred. Does the jurisdiction, for example, operate on a rule of law basis? It would be safe to say that the USA does do that, but to give a current example, you wouldn't want to transfer data to Russia, even if every other box had been ticked, simply because the jurisdiction doesn't really operate on a rule of law basis. So I'm now going to pass over to Emma, and she is going to talk a bit more about scrutiny, international transfers and market trends.
Thanks, Tom. So good afternoon, everyone. My name is Emma Harris, and as Tom's already mentioned, I'm a solicitor in the team here at Ashfords. I'm going to be speaking to you about scrutiny around international transfers and market trends, with a particular focus on the second Schrems decision, the implications of Schrems, the burdens placed on data exporters, and the scrutiny on international transfers in the EU courts. So, to recap, until 2020, the Privacy Shield scheme served to legitimise data transfers from the UK or the EU to the USA for organisations certified by the Privacy Shield. However, following the much publicised Schrems decision, Privacy Shield scheme was ruled inadequate, and the USA hasn't been granted an adequacy decision by either the UK or the EU. So for those who would benefit from a reminder, the facts of the Schrems case are that in 2015, the Austrian privacy advocate Max Schrems lodged a complaint with the Irish Data Protection Commissioner, alleging that the transfer of his personal data from Facebook Ireland to its parent company in the United States, made on the basis of the standard contractual clauses, didn't protect his fundamental rights under EU law, given the ability of the US public authorities to carry out surveillance on EU individuals' personal data without adequate controls or judicial remedies. He argued that the DPC should suspend those particular transfers, but not the SCCs generally. In contrast, the DPC took the view that the SCCs are part of a systemic problem and should be invalidated. So, as a result of the judgment, it brought the standard contractual clauses into question, and SCCs can no longer be used as a tick box exercise to say that appropriate safeguards are in place, and instead data exporters need to risk assess the data importer to decide if SCCs are an appropriate safeguard. So for the purpose of assessing the adequacy of the level of protection for transfers made pursuant to SCCs, the CJEU has confirmed that organisations must make an assessment to ensure, as required by Article 46(1), that data subjects are afforded appropriate safeguards, enforceable rights, and effective legal remedies. This assessment must involve both the provisions of the standard contractual clauses themselves and the laws of the country in which the data importer is based. Now, a practical point to consider is what type of personal data is being transferred and the status of the importer, and additionally cybersecurity, so what the importer's security systems are like. When assessing the laws of the data importer, factors might include, but they're not strictly limited to the following list, and it includes those adopted by the EU Commission when evaluating whether an adequacy decision is made, and these might include the rule of law, access by public authorities to the personal data, and redress avenues. In addition, parties may need to supplement the SCCs to overcome any shortcomings. So, for example, if the relevant surveillance can only take place in transit under the data importers law, then encrypting the personal data in transit might be an appropriate safeguard. So, as a result of the Schrems decision, this has placed a burden on data exporters, and it's created a number of challenges, which include that information isn't readily available, local law advice is costly, and large off-the-shelf providers of IT infrastructure are largely based in the US with limited cost-effective alternatives available. So to dig a little deeper into the burdens I've just described, information not being readily available, as discussed previously, Schrems suggests that exporters should evaluate and appraise the importer's legal system to the extent that it permits access by public authorities to personal data, and this exercise in itself can be convoluted or difficult to navigate, and the threshold of data exporters is high. When assessing the data importer's legal system, factors might include circumstances in which access to the data is permitted, oversight of the access, and as previously mentioned, the redress options available. Now, one way to go about this assessment is to undertake a transfer impact assessment. We don't have the time to go into the depths of these today, but please contact us if you have any queries or about the process for completing one. And it can be tricky to complete the required assessment where the data importer laws are opaque, require specialist advice, or the standards to be met are unclear. There's also scope to argue that there'll be differences in opinion between exporters who want to export and read importer laws more restrictively, and data activists who seek the best possible protection and will read the importer laws more expansively. So the CJEU reiterated that data exporters are primarily responsible for the assessment of adequacy of SCCs and supplements. And this poses a significant risk when IT service suppliers are largely based in the US. And finally, looking at EU to US data flows currently being scrutinised in the EU courts in the context of Google Analytics. So at the tail end of last year, the EU saw its first decision issued for a relevant failure to comply with international transfer obligations. And following a complaint by NOYB, which is an organisation initiated by Max Schrems, the Austrian Data Protection Authority issued a decision stating that a company's use of Google Analytics and thereby the transfer of data to Google in the US, constituted an unlawful data transfer. And the reason for this was that the SCCs relied upon didn't safeguard the transfer of personal data to the USA, and due to the ability for the US intelligence agencies to access that personal data. At the start of this year, the Dutch Privacy Agency warned that using Google Analytics may soon be illegal. And hot on the heels of the Austrian decision, the French privacy regulator ruled that an unnamed website couldn't use Google Analytics because doing so involves the transfer of personal information from Europe to US in violation of the Schrems decision. The Norwegian data watchdog has advised companies to start looking for alternatives to Google's tools. So the cases described highlight the marked clampdown on data transfers, and whilst the UK isn't bound by these decisions, they're perhaps a sign of things to come. So I think the key point to take away is to note that SCCs have been called into question and organisations need to be going a step further than what was previously acceptable. And we need to be looking closely at the laws of the data importer. And we're seeing that in some countries, parties are putting in place a separate data processing addendum in addition to the SCCs. So we've only scraped the surface here of some of the challenges that organisations are facing in the wake of Schrems. And we're already seeing large providers such as AWS offer data ring fencing products where the data is stored within the UK and the EEA to avoid data transfers to third countries. And there's likely to be growing pressure for others to do the same.
Brilliant. Thanks very much, Emma. Great. So I'm now going to delve a little bit deeper into approved transfer clauses and specifically the new UK International Data Transfer Agreement. So as Tom helpfully outlined at the start, where you're a UK organisation and you're looking to transfer personal data to a third country which hasn't received an adequacy decision, you're going to need to put in place appropriate safeguards. Now, the most common form of safeguard used by majority of organisations and companies are approved transfer clauses. And the new UK International Data Transfer Agreement, which comes into force on Monday, is a key example of one of these. Now, a quick word of warning, which both Tom and Emma have mentioned, and that is that you can't just use approved transfer clauses as a tick box mechanism. You really need to delve into the full matrix of facts behind the data importer. So looking at the importer destination laws, looking at security measures, looking at its reputation, and carrying out a transfer risk assessment. And only once you've done that can you decide whether it is appropriate to use standard contractual clauses or the UK International Data Transfer Agreement. But presupposing that we've carried out that transfer risk assessment and we're happy that it is acceptable for us to use those transfer clauses to safeguard the data, I'm then going to delve into what those approved transfer clauses look like and when you should be using each set. So the new UK IDTA, which comes into force on Monday, this is a really welcome development because until now, the UK have been in a situation where we've had to rely on the old EU SCCs. Now, these predated the GDPR, so they were no longer fit for purpose, they're outdated. And in light of this, the EU have actually issued a revised set, which came into force last summer. But because the UK had left the EU at that stage, we've been left with this interim period where we've been waiting for the ICO to follow suit. But while they've been doing so, we've been left having to rely on the old EU SCCs. But from Monday, we're going to have our own updated version of the transfer clauses, which now align with the current data protection laws in the UK. So that's great news. So because we've now got the UK IDTA, International Data Transfer Agreement, and we've got the EU SCCs, it's going to be really important for companies to look at what personal data it is that they're exporting. So is this UK personal data? Is it data that relates to EU data subjects, or is it a combination of the two? Now, if we take the example of a UK company with only a UK customer base, and they want to appoint a US CRM provider, now that's going to involve exporting UK personal data to the US. There's no EU personal data involved, and so we would use just the UK International Data Transfer Agreement. If we then compare this with the scenario where you've got a EU organisation, that EU organisation has got a solely EU workforce, and they want to procure a US employee management tool, for example. Now, again, we're looking at transfer to the US, but this time we're talking about EU personal data. And for that reason, there's no UK personal data involved, and so we would use the EU SCCs. For a lot of companies out there, though, it's not as simple as categorising the data as UK or EU, and it doesn't necessarily neatly fit into either camp. And often you'll have customers that are both UK and EU based, or employees that are both EU and UK based. And in that scenario, where you're exporting both EU and UK personal data, you can use the EU SCCs with the new UK addendum. Now, this new UK addendum comes into force on Monday as well, alongside the UK IDTA. And what it does is it extends the protection of the EU SCCs so that they also apply to UK personal data. And it saves parties signing one separate international data transfer agreement under UK law and a separate set of EU SCCs under EU law. And instead, the addendum is added into the EU SCCs and extends their protection. So it doesn't actually alter how the EU SCCs apply or impact the EU data, which is great because it doesn't affect their enforceability under EU law, but it does make certain limited amendments only in respect of the UK data. And examples of these are simply updating references to the EU to the UK. References to the EU GDPR will be amended to UK data protection laws. And also important to note that the governing law for that aspect of the clauses will be the laws of England and Wales. Parties can also choose to use laws of Scotland or laws of Northern Ireland, depending on where they're based. But the starting position will be the governing laws of England and Wales. Now, one final important reminder that I just wanted to note, because it's something that's quite topical at the moment and something that a lot of people are talking about, and that's this gap that we've got with the EU SCCs. Now, where you want to transfer personal data from the EU to a data exporter in a third country, but that data importer is already subject to the EU GDPR, for example, because it offers goods or services to data subjects in the EU, or potentially they monitor the behaviour of data subjects in the EU. So for those reasons, they're already themselves subject to the EU GDPR. You can't use the EU SCCs for that transfer, and that's confirmed in recital 7 of the EU SCC's implementing decision. And it leaves this gap of data importers where there currently are no EU standard approved clauses which are fit for purpose for that transfer. Now, helpfully, the UK International Transfer Agreement doesn't have this same gap, but it's worth noting that that gap exists for the EU transfers. And it's something that we're waiting for the European Commission to provide a solution for. So a case of sort of mentioning that and one to watch going forward. So hopefully that's a helpful picture of how the different transfer agreements fit together and when you should use each one. What I now want to do is really hone in onto the UK International Data Transfer Agreement that comes into force next week. And so on the slide here, we've got the key dates. So firstly, Monday, we've got the IDTA coming into force, and we've then got a 6-month grace period until the 21st of September. And during this period, you can still sign the old EU SCCs, but after this date, you won't be able to. And what this grace period acknowledges is that it's not an overnight process for companies to roll out the new data transfer agreement, and they need a bit of time to get this up and running. We've then got a 2-year period to transition all existing arrangements, which are currently in place using the old EU SCCs onto the new version of the data transfer agreement. Now, 2 years does seem like a long time, but if you've got a large number of contracts and you're reliant on counterparties to engage with the process and obviously to go through various signature processes, it's always sensible to start early because you never want to have a mad rush at the end. Obviously, we've noted here that we are just talking about the UK International Data Transfer Agreement, but I thought it would also be useful to note that where you're exporting EU personal data and you need to transition from the old EU SCCs onto the new EU SCCs, the time frame for transitioning these is slightly shorter. So you've got until 27th of December this year to transition those arrangements. So now turning to the key developments, and these are the things that I think are sort of a useful summary of the key differences when we compare the UK data transfer agreement to the previous EU SCCs that we've been having to rely on. And yeah, sort of a useful summary of the improvements that have been made. So most importantly, I think they are far more user-friendly and they're really easy to complete. So they've got a simple tick box section at the top, which enables the parties to really tailor them to their specific scenarios and select different options, such as whether they want certain termination rights to apply. Now, secondly, they also cover the full range of plausible data processing relationships. So one of the key failings of the previous EU SCCs was that there were certain data protection relationships that they didn't cover. So two examples being where the data exporter was the processor and the data importer in the third country was a controller, and also where you've got a processor exporting to a sub-processor. So neither of those scenarios were previously covered. Now they are. So it means that the new UK data transfer agreement is going to be really accurate and it's going to be really tailored to the specific scenario. Or we've already touched upon this, but one of the benefits of the UK IDTA when compared to even the updated EU SCCs is that it can be used with this category of data importers that are already subject to the UK GDPR. Now, these data importers might be subject to the UK GDPR for the same reasons, so because they offer goods and services to data subjects in the UK, or because they monitor their behaviour. But this isn't going to stop you using those model clauses or those data transfer clauses with that data importer. So unlike the EU, we don't have a gap here. Now, a further really positive development is that future revisions to the ICO data transfer agreement are going to automatically take effect. So every time the ICO issues an update or revision, you're not going to have to go through and sign a new set of the clauses again, which is going to save a lot of time. And the agreement also includes a complementary or a supplementary termination right, which you can select to apply within that cover sheet that I mentioned as a tick box. And effectively what this does is it ensures that if there was an amendment or a revision made by the ICO and this substantially increased the risk or the cost to either party, they could rely on that to then terminate the agreement. They do have to demonstrate that they've taken reasonable steps to reduce that risk or that cost. And so ultimately, it's probably going to be a preferred approach to rely on any termination for convenience rights that you may have agreed, because you then don't have to establish that you have suffered any increase in risk or cost, but an important one to be aware of. And then finally, the new UK data transfer agreement has a designated section for extra protection clauses to be added in. So where you've completed that transfer risk assessment at the outset and you've determined that actually this UK IDTA by itself isn't going to be an appropriate safeguard and we need to go further and we need to supplement it, you can then add in those extra protection clauses that you're choosing within the designated box. So examples being contractual obligations to comply with certain security measures, and also potentially prior notice or a consultation period if there ever was a data disclosure request. So just a few examples of the kind of extra protection clauses we're seeing in practice. Now, hopefully that's been a helpful summary of the current status of international transfers and also the new UK International Data Transfer Agreement. Thank you very much for joining us. And if anybody did have any questions, please do feel free to email us. And I'll just leave that slide up there that's got each of our email addresses on.